Good day, everyone. I am Michael Dave Cruz Vinluan, and I'm here today with Miss Estrelyn Amparo, Miss Hazel Suarez, and Mr. Neil Hechanova to discuss to you Philippine jurisprudence concerning Section 13 of the Bill of Rights, or the right of a person to bail. But before we tackle decided cases, let us first define the word bail. So, bail is defined as the security given for the release of a person in custody of the law, furnished by him or a bondsman, conditioned upon his appearance before any court as may be required. Now we know what bail is. Let us now learn what the Constitution say about a person's right to bail. Now we can find this under Section 13, Article 3 of the 1987 Constitution, which provides that all persons, except those charged with offenses punishable by reclusion perpetua, when the evidence of guilt is strong, shall before conviction be bailable by sufficient sureties, or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. With all that said, let us dive deep on these cases decided by the Supreme Court on the right to bail under Section 13. Now, we have Miss Hazel Suarez to start us off.
So in the case of Basco versus Rapatalo, the complainant Inocencio Basco charged respondent judge Leo Rapatalo with gross ignorance or willful disregard of established rule of law for granting bail to accused Roger Morente in a murder case without receiving evidence and conducting a hearing. Next slide, please. The respondent judge contended that he granted the petition based on the prosecutor's option not to oppose the petition, as well as the latter's recommendation setting the bail bond in the amount of 80,000 pesos. He also claimed that when the prosecution chose not to oppose the petition for bail, he has the discretion on whether to approve it or not. The issue in this case is whether a petition for bail can be granted without conducting a hearing. The Supreme Court held in this case that no, a hearing is mandatory when an application for bail is made. The discretion may rightly be exercised only after the evidence is submitted to the court at the hearing. Furthermore, in the application for bail, a person charged with a capital offense, a hearing must actually be conducted to determine whether the evidence of guilt against the accused is strong. Next slide, please. The Supreme Court also stated that another reason why hearing of a petition for bail is required is for the court to take into consideration the guidelines set forth in Section 6, Rule 114 of the Rules of Court in fixing the amount of bail. So, for the case of People versus Donato, next slide please. Private respondent Rodolfo Salas, alias Commander Bilog, and his co-accused were charged for the crime of rebellion. At the time the information was filed, Salas and his co-accused were in military custody. A petition for habeas corpus was filed for Salas. However, it was dismissed on the basis of the agreement of the parties that they will remain in legal custody and will face trial before the court having custody over his person. Private respondent filed a petition for bail, which petitioner opposed on the ground that rebellion became a capital offense under Presidential Decree numbers 1996, 942, and 1834, which imposes the penalty of reclusion perpetua to death on those who promote, maintain, or head a rebellion, resulting to the accused no longer being entitled to bail. On June 5, 1987, the President issued an Executive Order 187 repealing among others the said presidential decree and restoring the full force and effect of Article 135 of the revised Penal Code. Thus, the original penalty for rebellion, which was prison mayor and a fine not exceeding 20,000 pesos, was restored. So the issue in this case is whether the right to bail was validly waived by the private respondent. The Supreme Court held in this case that yes, that Salas expressly waived his right to bail when he agreed to remain in legal custody and face trial before the court in exchange for the withdrawal of the petition for habeas corpus, and that both his co-accused be immediately released but shall appear at the trial of the criminal case for rebellion filed against them. The court further stated that despite agreeing to the respondent court that bail cannot be denied in accordance with the 1987 Constitution and the rules of court, the right to bail can be waived as a constitutional right. It is a right which is personal to the accused and whose waiver would not be contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person.
So our next case is People versus Fortes. The facts of the case: on November 26, 1983, Agripino Gine accompanied his 13-year-old daughter Marilyn to the police station to report a rape committed against the latter by the Fortes. Accused appellant, who is the accused appellant for this case. Following this, the accused was forthwith apprehended. On December 5, 1983, Agripino Gine filed on behalf of Marilyn complaint for rape against the accused before the Municipal Circuit Trial Court of Matnog, Santa Magdalena in Matnog, Sorsogon. On January 25, 1989, the trial court promulgated its decision convicting the accused of the crime charge. The dispositive portion thereof reads, wherefore this court finds the accused guilty beyond reasonable doubt of the crime of rape and sentences him to suffer the penalty of reclusion perpetua and to indemnify Marilyn Gine the sum of 20,000 pesos as damages and to pay the cost. The accused is ordered committed to the Sorsogon Provincial Jail through the provincial warden or through any of his provincial guards and eventually committed to the National Penitentiary in accordance with the law, and so ordered. On the same day, the accused filed his notice of appeal wherein he requested that the amount of the appeal bond be fixed by the trial court. The following day, the trial court gave due course to the appeal but did not resolve the request to fix the amount of bail. Thus, on 11 of April 1989, the accused filed an application for bail on appeal, reiterating his earlier request that the bail bond for his provisional liberty pending appeal be set. This was subsequently denied by the trial court in its order of June 19, 1989 on the ground that the accused has already been found guilty beyond reasonable doubt of the offense of rape and sentenced to reclusion perpetua and his appeal from the decision already approved by the court. Thereupon, on August 19, 1989, the trial court issued a commitment of final sentence, turning over the person of the accused to the Director of Prisons in Muntinlupa, Metro Manila. And on August 25, 1989, the accused filed a motion to reconsider the Regional Trial Court's order denying his application for bail pending appeal, but the same was denied. Hence, the accused filed the Supreme Court a special civil action assailing the trial court's refusal to grant his application for bail pending appeal on the ground that the same amounted to an undue denial of his constitutional right to bail. He contends that before his conviction by final judgment, he enjoys the constitutional presumption of innocence and is therefore entitled to bail as a matter of right. The issue of the case is whether or not Fortes is entitled to bail. The ruling of the court is in the negative. The Supreme Court, speaking through Justice Davide Jr., declared that it is clear from Section 13, Article 3 of the 1987 Constitution, as well as Section 3, Rule 114 of the Revised Rules of Court as amended, that before conviction, bail is either a matter of right or discretion. It is a matter of right when the offense charge is punishable by any penalty lower than reclusion perpetua. To that extent, the right is absolute. Upon the other hand, if the offense charge is punishable by reclusion perpetua, bail becomes a matter of discretion. It shall be denied if the evidence of guilt is strong. The court's discretion is limited to determining whether or not evidence of guilt is strong. But once it is determined that the evidence of guilt is not strong, bail also becomes a matter of right. The clear implication, therefore, is that if an accused who is charged with a crime punishable by reclusion perpetua is convicted by the trial court and sentenced to suffer such a penalty, bail is neither a matter of right on the part of the accused nor of discretion on the part of the court. In such a situation, the court would not have only determined that the evidence of guilt is strong, which would have been sufficient to deny bail even before conviction. It would have likewise ruled that the accused's guilt has been proven beyond reasonable doubt. Bail must not then be granted to the accused during the pendency of his appeal from the judgment of conviction. Construing Section 3, Rule 114 of the 1985 Rules on Criminal Procedure as amended this court in the en banc resolution of October 15, 1991 in the case of People versus Ricardo Cortez ruled that pursuant to the aforecited provision, an accused who is charged with a capital offense or an offense punishable by reclusion perpetua shall no longer be entitled to bail as a matter of right, even if he appeals the case to this court, since his conviction clearly imports that the evidence of his guilt of the offense charged is strong. In the instant case, the rape for which the accused was indicted is punishable by reclusion perpetua pursuant to Article 335 of the Revised Penal Code. He was convicted, therefore, and subsequently sentenced to serve that penalty. It is thus evident that the trial court correctly denied his application for bail during the pendency of the appeal. Based on this reason, the Supreme Court affirmed that the appealed decision of the RTC and denied the petition for lack of merit. Our next case is Comendador versus De Villa. The facts of the case here, 4 cases have been consolidated because they involve practically the same parties and related issues arising from the same incident. The petitioner in GR number 93177 and 96948 and the private respondents in GR number 95020 and 97454 are officers of the Armed Forces of the Philippines, facing prosecution of their alleged participation in the failed coup d'etat that took place on December 1 to 9, 1989. Before the charges were referred to General Court-Martial, a pre-trial investigation panel had been constituted to investigate the petitioners in GR number 93177 and 96948. The pre-trial investigation panel issued a subpoena individually addressed to the petitioners. The charges against them are violations of Article of War 67 or mutiny, and also the Articles of War 96 or the conduct and becoming an officer and a gentleman. And also it includes the Articles of War 94 or various crimes in relation to Article 248 of the Revised Penal Code, or what we call murder. Lieutenant Colonel Jacinto Ligot applied for bail, but the application was denied by the General Court-Martial number 14. He thereupon filed with the Regional Trial Court of Quezon City a petition for certiorari and mandamus with prayer for provisional liberty and a writ of preliminary injunction. After considering the petition and the answer thereto filed by the President and members of the GCM number 14 or the General Court-Martial, Judge Maximiano C. Asuncion issued an order granting provisional liberty to Ligot. Ligot filed an urgent omnibus motion to enforce the order for his release and to declare in contempt the commanding officer of the PC or INP jail for disobeying the said order. He later also complained that Generals de Villa and Aguirre had refused to release him pending final resolution of the appeal to be taken. After hearing, the trial court reiterated its order for the provisional liberty of Ligot, as well as of intervenors Lieutenant Colonel Franklin Browner, Lieutenant Colonel Arsenio Texon, and Major Alfredo Oliveros, and later of additional intervenors Lieutenant Colonel Romelino Gojo and Captain Manuel Ison. The trial court rendered judgment declaring that Section 13, Article 3 of the Constitution granting the right to bail to all persons with the defined exception is applicable and covers all military men facing court-martial proceedings. Accordingly, the assailed orders of General Court-Martial Number 14 denying bail to petitioner and interveners on the mistaken assumption that bail does not apply to military men facing court-martial proceedings on the ground that there is no precedent are hereby set aside and declared null and void. Respondent General Court-Martial Number 14 is hereby directed to conduct proceedings on the applications of bail of the petitioner, interveners, and which may as well include other persons facing charges before General Court-Martial Number 14. Pending the proceedings on the applications for bail before the General Court-Martial Number 14, the court reiterates its orders of release on the provisional liberty of petitioner Jacinto Ligot, as well as interveners Franklin Browner and Arsenio Taxon. On February 18, 1991, the private respondents in GR number 97454 filed with this court a petition for habeas corpus on the ground that they were being detained in Camp Crame without charges. The petition was referred to the Regional Trial Court of Quezon City, where it was referred to Respondent Judge Antonio P. Solano. Finding after hearing that no formal charges have been filed against the petitioners after more than a year after their arrest, the trial court ordered their release. So the issue in this case is whether or not the right to bail may be invoked by the military. The ruling is in the negative. The Supreme Court declared that the right to bail invoked by the private respondents in GR numbers 95020 has traditionally not been recognized and is not available in the military as an exception to the general rule embodied in the Bill of Rights. This much was suggested in Arula, where we observe that the right to a speedy trial is given more emphasis in the military where the right to bail does not exist. The justification for this exception was well explained by the Solicitor General as follows. The unique structure of the military should be enough reason to exempt military men from the constitutional coverage under right to bail. Aside from the structural peculiarity, it is vital to note that the mutinous soldiers operate within the framework of the democratic system, are allowed the fiduciary use of firearms by the government for the discharge of their duties and responsibilities, and are paid out of revenues collected from the people. All other insurgent elements carry out their activities outside of and against the existing political system. National security considerations should also impress upon this honorable court that release on bail of respondents constitutes a damaging precedent. Imagine a scenario of, let's say, 1,000 Putskis roaming the streets of Metropolis on bail, or if the assailed, example, July 25, 1990 order were sustained, on provisional bail. The sheer number alone is already discomforting, but the truly disquieting thought is that they could freely resume their heinous activity, which could very well result in the overthrow of duly constituted authorities, including this honorable court, and replace the same with a system consonant with their own concept of government and justice. The argument that denial from the military of the right to bail would violate the Equal Protection Clause is not acceptable. This guarantee requires equal treatment only of persons or things similarly situated and does not apply where the subject of the treatment is substantially different from others. The accused officers can complain if they are denied bail and other members of military are not, but they cannot say that they have been discriminated against because they are not allowed the same right that is extended to civilians.
The next case is Bailon versus Judge Season. Next slide, please. The facts in this
On
case
October
are as
24,
follows. 1991, the Office of the City Prosecutor in Dagupan City filed an information for double murder against several accused, which was docket as criminal case number D-10678 entitled People of the Philippines versus Manolo Salcedo et al., and thereafter raffled to the respondent judge. Subsequently, the accused filed on November 8, 1991, a petition for investigation which was granted, and the Office of the City Prosecutor was given until December 23 to resolve the same. The reinvestigation was finally concluded by the said prosecutor on March 31, 1992. Next slide, please. On December 21, which was Saturday, during the pendency of the reinvestigation, however, the accused filed a petition for bail and requested that it be set for a hearing immediately following the Monday. Even with a strong opposition thereto by the prosecution, a hearing on the petition was purportedly held by the trial court. Next slide, please. Then, reportedly, on the basis of the joint counter-affidavit of the accused, an affidavit of one Oscar Villaga, a certification of entry in the police blotter, and the position paper submitted by the accused, and allegedly because there was no objection on the part of the prosecution, which was supposedly represented by the third assistant prosecutor, the court forthwith granted the bail for the provisional liberty of each accused in the amount of 40,000. Then a motion for reconsideration was filed, but it was denied. Next slide, please. The issue in this case, whether or not the granting of bail by the respondent judge was proper. The court ruled in affirmative. Respondent Judge Season stands charged with the now familiar malfeasance of granting bail in non-bailable offenses without the benefit of notice and hearing. Specifically, it was averred that the prosecution was not given notice for at least 3 days before the scheduled hearing on the petition for bail of in violation of the mandate under Section 4, Rule 15 of the Rules of Court, and worse, with the 2 non-working days between the filing and the hearing of the petition. It was likewise contended that during the controverted hearing on December 23, the prosecution, which was not even duly represented, was not given the opportunity to prove the evidence of guilt of the accused was strong. There are 2 main arguments invoked and relied on by the respondent judge to support and justify his grant of bail to the accused. That time was the time of the circumstances was essence, considering that the accused had been detained since October 21, and that the prosecution failed to interpose an objection to the granting of bail and to ask for an opportunity to prove the strength of the evidence of guilt against the accused. The court rejected the first Tenonius proposition that time was the essence, since the ambient circumstances obtaining prior to the grant of bail could not but have cautioned respondent judge to be more circumspect in entertaining and resolving the petition, therefore. Next slide, please. There are noted circumstances which are as follow. First, the accused were charged with double murder, each of which is punishable by reclusion perpetua to death. Hence, bail is not a matter of right. Second, no bail was recommended in the information which was filed on the basis of the sworn statement of several eyewitnesses to the incident, thus the constituting clear and strong evidence of guilt of all the accused. Third, that at the time of the application for bail, there was still pending investigation of the case being conducted by the Office of the City Prosecutor. It must be noted that the investigation was at the instance of the accused themselves. Hence, any resultant delay caused by the conduct is naturally and logically attributable to them. And finally, the willful setting of the hearing and the petition for bail was on December 23, when the same was filed only on December 21, which was a Saturday, readily a cast doubt on the good faith and the regularity of the procedure adopted by the defense. Next slide, please. On the second contention, it was categorically stressed that although the provisional prosecutor had interposed no objection to the grant of bail to the accused, the respondent judge therein should nevertheless have set the petition for bail for hearing and diligently ascertained from the prosecution whether the latter was not really contesting the bail application. Additionally, it must be borne in mind that a hearing is also necessary for the court to take into consideration the guidelines set forth in the Section 6, Rule 114 of the Rules of Court in fixing the amount of bail. It was only after the respondent judge has satisfied himself that these requirements under the law have been met, then it would proceed to the rule whether or not to grant the bail. Next case, Manotok versus Court of Appeals. Next slide, please. In this case, Manotok is one of the two principal stockholders of Transinsular Management Incorporated, which was a stock brokerage house. Following the run on stock brokerage caused by the stockbrokers Santa Maria's fight from this jurisdiction, which was the petitioner in this case, who was then in the US. He came home and together with the other stockholders, they filed with the Securities and Exchange Commission a petition for the appointment of a management committee, um, not only for Manotok Securities, but likewise for Transinsular Management. Next slide, please. On March 1, 1982, petitioner filed before each of the trial courts a motion entitled Motion for Permission to Leave the Country, stating as a ground, therefore, his desire to go to the United States relative to his business transaction and opportunities. The prosecution opposed the said motion, and after due hearing, both the trial judges denied the same because the court see no urgency for such to grant. The petitioner wrote to the petitioner wrote to the commissioner a letter requesting the recall of the RTC but was also denied. He then filed a petition for certiorari and mandamus before the Court of Appeals for the denying his leave to travel abroad. However, the Court of Appeals dismissed it for lack of merit. The petitioner contends that having been admitted to bail as a matter of right, neither the court which granted him bail nor the Securities and Exchange Commission, which has no jurisdiction over his liberty, could not prevent him from exercising his constitutional right to travel. Next slide, please. The issue in this case, whether or not a person facing a criminal indictment and provisionally released on bail have an unrestricted right to travel. Next slide, please. The court ruled in negative. The court has the power to prohibit a person admitted to bail from leaving the Philippines. This is necessary consequence of the nature and function of a bail bond. Indeed, if the accused were allowed to leave the Philippines without sufficient reason, he may be placed beyond the reach of the courts. The petitioner has not satisfied the duration of the proposed travel or shown that his surety has agreed to it. The petitioner merely alleged that his surety has agreed to his plan as he had posted cash indemnities. Next slide, please. The court cannot allow the accused to leave the country without the assent of the surety, because in accepting in a bail bond or recognizance, the government impliedly agrees that it will not make any proceeding with the principal that will increase the risk of the sureties or the effect of the remedies against him. So as the petitioner has failed to satisfy the trial court's requirement and the appellate court, because of the urgency of his travel, the duration thereof, as well as the consent of his surety to the proposed travel, thus the court find no abuse of judicial discretion in their having been denied the petitioner's motion for him to leave the country.
Now let us look at the case of the government of the United States of America versus Judge Puruganan. Now, this petition is a sequel of a case, which is the case of Secretary of Justice versus Ralph C. Lanchon. So, where the court held that Jimenez in that case was deprived of his right to notice and hearing during the evaluation stage of the extradition process. The government of the United States of America, represented by the Philippines Department of Justice, filed with the RTC the appropriate petition for extradition of Jimenez, as the latter was subject of an arrest warrant issued by the United States in Florida. Jimenez then filed an urgent motion or ex parte motion before the RTC could act on the said petition for extradition, which prayed for Jimenez application for an arrest warrant be set for hearing. Thus, the RTC granted the motion of Jimenez and set the case for hearing on June 5, 2001. After the hearing, the RTC required the parties to submit their respective memoranda. In his memorandum, Jimenez sought an alternative prayer that in case a warrant should issue, he should be allowed to post bail in the amount of 100,000 pesos. Thereafter, the RTC issued its July 3, 2001 order directing the issuance of a warrant for Jimenez arrest and fixing bail for his temporary liberty at 1 million pesos in cash. After Jimenez had surrendered his passport and posted the required cash bond, Jimenez was granted provisional liberty, hence this petition. Now, the issue in this case is whether or not Jimenez is entitled to bail while the extradition proceeding are pending. So the ruling of the Supreme Court is that no, the Supreme Court, speaking through Justice Panganiban, declared that the use of the word conviction under Section 13, Article 3 of the Bill of Rights or the 1987 Constitution, as well as Section 4 of Rule 114 of the Rule of Courts on Bail, applies only when a person have been arrested and detained for violation of Philippine criminal laws. It doesn't apply to extradition proceedings because extradition courts do not render judgment of conviction or acquittal. Moreover, the constitutional right to bail flows from the presumption of innocence in favor of every accused who should not be subjected to the laws of freedom, as thereafter he would be entitled to acquittal unless his guilt be proved beyond reasonable doubt. Now it follows that the constitutional provision on bail will not apply to a case where
Like
the
extradition.
presumption of innocence is not an issue. The provision in the Constitution stating that the right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended, it does not detract from the rule that the constitutional right to bail is available only in criminal proceedings. It must be noted that the suspension of the privilege of habeas corpus finds application only to person judicially charged for rebellion or offenses inherent or in directly connected with invasion. Hence, the second sentence in the constitutional provision on bail merely emphasizes that the right to bail in criminal proceedings for the basically the right to bail merely emphasizes the right to bail in criminal proceeding for the aforementioned offenses. It cannot be taken to mean that the right is available even in extradition proceedings that are not criminal in nature. That the offenses
Jimenez.
for which is sought to be extradited are bailable in the United States is not an argument to grant him one in the present case. To stress, extradition proceedings are separate and distinct from the trial for the offense for which he is charged. He should apply for bail before the courts trying the criminal case against him, not before the extradition courts. Now let's talk about the exemption to the no bail rule. So the rule, as repeated by the Supreme Court, is that bail is not a matter of right in extradition cases. However, the judiciary has the constitutional duty to curb grave abuse of discretion and tyranny, as well as the power to promulgate rules to the protection and enforcement of constitutional rights. Furthermore, the Supreme Court believes that the right to due process is broad enough to include the basic uh, to include the grant of basic fairness to extraditees. Indeed, the right to
the
due
life,
process extends liberty or property of every person. It is dynamic and resilient, adaptable to every situation, calling for its application. Now, accordingly, and to best serve the ends of justice, the Supreme Court declared that after a potential extraditee has been arrested or placed under the custody of the law, bail may be applied for and granted as an exemption only upon
convincing showing that
clear and
one,
once granted bail, the applicant will not be a flight risk or danger in the community, and two, that there exist special humanitarian and compelling circumstances, including as a matter of reciprocity, those cited by the highest court in the requesting state when it grants provisional liberty in extradition cases therein. So, since this exemption has no express or specific statutory basis, and since it is derived essentially from general principles of justice and fairness, the applicant bears the burden of proving the above two-tiered requirements with clarity, precision, and empathic forcefulness. Extradition is basically an executive, not a judicial responsibility arising from presidential power to conduct foreign relations. In its barest concept, it partakes the nature of police assistance among states, which is not normally a judicial prerogative. Hence, any intrusion by the courts into the
should be
exercise of this
characterized
power by caution, so that the vital international and bilateral interests of our country will not be unreasonably impeded or compromised. In short, the Supreme Court is ever protective of the sporting idea of fair play, but it also recognizes the limits of its own prerogatives and the need to fulfill international obligation. Hence, based on these reasons, the assail decision of the RTT judge granting Jimenez bail was declared null and void. Now let's move to the last case in this reporting, which is the case of Juan Ponce Enrile and Sandigan Bayan. So the facts of this
on
case
June
are as
5,
follows.
2014,
The Office of the Ombudsman charged Enrile and several others with plunder in the Sandigan Bayan on the basis of their purported involvement in the diversion and misuse of appropriations under the PDAF or the Priority Development Assistance Funds. Hence, Enrile respectively filed his omnibus motion and supplementary opposition, praying among others that he be allowed to post bail should probable cause be found against him. The motions were heard by the Sandigan Bayan after the prosecution filed its consolidated oppositions. Now, on July 3, 2014, the Sandigan Bayan issued its resolution denying Enrile's motion, particularly on the matter of bail, on the ground of its prematurity, considering that Enrile has not yet voluntarily surrendered or been placed under the custody of the law, and accordingly, the Sandigan Bayan ordered the arrest of Enrile. Now, on the same day, the warrant for his arrest was issued. Enrile voluntarily surrendered. So, at Camp Crame, Quezon City, and was later on confined at PNP General Hospital following his medical examination. Now, thereafter, Enrile filed his motion for detention at the said hospital, and his motion to fix bail, which were heard by the Sandigan Bayan on July 8 2014. In support of his motions, Enrile argued that he should be allowed to post bail because A, the prosecution had not yet established that his guilt
B,
was
that
strong.
although
Although he was charged with plunder, the penalty as to him would only be reclusion temporal, not reclusion perpetua, and that he was not a flight risk. his age, physical condition must be further taken seriously, and therefore it must be considered. Now, later on, the Sandigan Bayan issued its first assailed resolution denying any this motion to fix bail on the ground that it is only, or basically by saying that it is only after the prosecution shall have presented its evidence and the court shall have made a determination of the evidence of the guilt is not strong against the accused Enrile, can he demand bail as a matter of right. Now, accused Enrile argued that the maximum penalty that may be possibly imposed to him is reclusion temporal, not reclusion perpetua, and also that he is also 70 years old and that he voluntarily surrendered. Accordingly, it may be said that the crime charged against Enrile is not punishable by reclusion perpetua and thus bailable. The Sandigan Bayan found no merit on Enrile's arguments, and thus this motion to fix bail was denied. Hence, basically, this petition. Now, the issue in this case is whether or not Enrile is entitled to bail. Here is the ruling of the court. Now, on the issue that bail may be granted as a matter of right or discretion, according to the Supreme Court, the right to bail is expressly afforded by Section 13 of the Bill of Rights and is also repeated in Section 7, Rule 114 of the Rules of Court as follows. Section 7 provides that no person charged with capital offense or an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Now, a capital offense in the context of the rule refers to an offense that, under the law existing at the time of its commission and the application for admission to bail, may be punished by death. The general rule is therefore that any person, before being convicted of any criminal offense, shall be bailable unless he is charged with a capital offense or with an offense punishable with reclusion perpetua or life imprisonment, and the evidence of his guilt is strong. Hence, from the moment he is placed under arrest or is detained or restrained by the officers of the law, he can claim the guarantee of his provisional liberty under the Bill of Rights, and he retains his right to bail unless he is charged with a capital offense or with an offense punishable with reclusion perpetua or life imprisonment, and the evidence of his guilt is strong. Once it has been established that the evidence of his guilt is strong, no right to bail shall be recognized. As a result, all criminal cases within the competence of the METC, MTC, MTCC, or MCTC are bailable as a matter of right because these courts do not have jurisdiction to try capital offenses or offenses punishable with reclusion perpetua or life imprisonment. Likewise, bail is a matter of right prior to conviction by the RTC for any offense not punishable by death, reclusion perpetua, or life imprisonment, or even prior to um, conviction for an offense punishable by death, reclusion perpetua, or life imprisonment when evidence of guilt is not strong. On the other hand, the granting of bail is discretionary upon conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, or two, if the RTC has imposed a penalty of imprisonment exceeding 6 years, provided none of the circumstances enumerated in paragraph 3, section 5 of Rule 114 is present as follows. So that he must not be a recidivist, quasi-recidivist, or habitual delinquent, or has committed the crime aggravated by the circumstance of reiteration. Now that he has been previously escaped from legal confinement, evaded sentence, or violated the conditions of his bail without valid justification. Letter C, that he committed the offense while under probation, parole, or conditional pardon, that the circumstances of his case indicate the probability of being a flight risk, okay, or flight if released on bail. And letter E, that there is undue risk that he may commit another crime during the pendency of the appeal. Now on Enrique's poor health, which justify his admission to bail, the court said that it is mindful of the Philippines' responsibility in the international community arising from the national commitment under the Universal Declaration of Human Rights to uphold the fundamental human rights as well as to value the worth and dignity of every person. This commitment is enshrined under Section 2, Article 2 of the Constitution, which provides that the state values the dignity of every human person and guarantees full respect for human rights. The Philippines, therefore, has a responsibility of protecting and promoting the right of every person to liberty and due process, ensuring that those detained or arrested can participate in the proceedings before a court to enable it to decide without delay on the legality of the detention and order the release if justified. Now, this national commitment to uphold the fundamental human rights, as well as the value and worth and dignity of every person, has authorized the grant of bail, not only to those charged in criminal proceedings, but also to extraditees upon clear and convincing showing that one, the detainee will not be a flight risk or a danger in the community, and two, that there exists a special humanitarian and compelling circumstance. The view of the Supreme Court is that Enrile's social and political standing and his having immediately surrendered to the authorities upon his being charged in the court indicate that the risk of his flight or escape from the jurisdiction is highly unlikely. Furthermore, Dr. Gonzalez attested that the following medical conditions, singly or collectively, could pose significant risk to the life of Enrile. So these are those medical conditions. It
Okay.
is relevant to observe that granting provisional liberty to Enrile will then enable him to have his medical condition be properly addressed and better attended to by competent physicians in the hospital of his choice. This will not only aid in his adequate preparation of his defense, but more importantly, will guarantee his appearance in court for the trial. Based on these reasons, the Supreme Court concluded that the Sandigan Bayan arbitrarily ignored the objective of bail to ensure the appearance of the accused during trial and unwarrantedly disregarded the clear showing of the fragile health and advanced age of Enrile. As such, the Sandigan Bayan gravely abused its discretion in denying Enrile's motion to fix bail. That is all for this reporting, and on behalf of Ms. Ezalyn Amparo, Ms. Hazel Suarez, and Mr. Neil Hechanova, we would like to extend to you our sincerest gratitude for making it up to the end of this video. We hope that you learned something new today, and we wish you nothing but success in your pursuit of the study of law. This journey. God bless you and have a wonderful day. Thank you.